Greetings, my name is Rasmussen. I'm one of the partners here at Lagerlof, and I want to speak to you today about letters of intent. Why bother with them, what they are. So let's consider that you're looking at doing a significant commercial real estate transaction or a corporate deal or business deal, and the issue of a letter of intent comes up. I look at a letter of intent as different from a term sheet, say, in that it tends to be more robust. It will have all of the key essential terms of a transaction. It will also typically say that the terms of the letter of intent are non-binding until a definitive agreement is put together. There may be some exceptions to that we'll talk about. We'll usually have a time frame for which the parties can agree upon those terms, and most significantly, it will be signed by all of the parties to the transaction. So, if it's non-binding, why bother with having a letter of intent? Well, one of the key reasons is that it makes sure that the parties are in agreement on all of the key terms of the deal before spending a lot of time and expense on the transaction. The second thing is it can provide a nice roadmap for whoever is going to put together the definitive agreement to know what the terms are. It can expedite that process. Another reason is it can provide a basis for approval, say a lender approval or board approval that can expedite that process as well. So those are some key reasons. One of the things you want to keep in mind on a letter of intent, though, is to make sure that it states that it's non-binding. There are many people who have found out that just saying it's a letter of intent isn't enough to make it non-binding. It needs to expressly state that in the document. There may be some reasons to have exceptions to that. For example, it may be important that the transaction have a confidentiality provision. So the letter of intent may say that the parties will agree to keep it confidential, and that is binding on the parties. It may also be important to have an exclusivity provision. So if you're a buyer, it's important that your letter of intent isn't used by the seller to go out and shop the deal elsewhere. So you create a period of time in which there is an exclusive agreement to work together. Maybe it's 30 days until the letter of intent, until the final document is put together. So even though it's non-binding, in some sense, in a practical and tactical level, it is binding. It is the penultimate handshake. You've agreed on these terms, and it'll be difficult, if not impossible, to move forward on a deal on different terms. The one thing I'd like to encourage you is to make sure you have the lawyer involved at the letter of intent stage. Too often we're handled a signed letter of intent, and there are terms in there that are missing, there's ambiguities, there's unfavorable terms that could have been addressed if we had been involved at the outset. So be sure to get the attorney involved at the letter of intent stage. So that's just a brief overview of letter of intent, where the attorneys here at Lagerlof are fully capable of handling any kind of corporate or commercial real estate transaction, and we look forward to helping you with your needs. Thank you.